You don't, Tyler Shaw?
I'll look him up.
Thanks, Sarah.
Sure. what?
Because you have to put the toggle in the thing. That's why it is.
How come you don't leave the toggle in there?
Because when I just throw this in the bag and then I go back,
So I don't.
there'll be all these windows open and
No.
things typed.
Legal aid.
Legal aid does not do guardianship. And I even,
I'll be honest, I set up my office and these computers and they're like, do you want more? And I'm like, if you just set me up once, you'll never hear from me again.
You found it.
There's gotta be somebody that
This one
will.
looks like it has more
I just
cases
have
in
to- I don't
it
know
than the
about
one he
my-
gave us yesterday.
He added some stuff. He said,
they do it, which is why it's so crazy.
You could creatively,
Unless a private attorney does it pro bono, but even he does
that'd be a bad resource to, maybe reach out to Dr. McDonald to see if she's aware of anything or if there's anything that she can do. But anyway, let's circle back around to that.
The last thing that we found out was that if we, because
All rise. Clerk court is now in session. The Honorable William Stone presiding.
Good morning, please be seated.
Yeah. That's a pain. All right, Mr. Weinstock.
Number one on your rogues gallery, Judge.
I noticed someone's humor this morning.
Your Honor, I have two cases in front of you. Prolwitz. James Prolwitz on case number 24 CF 178.
Ms. Weinstock, can you take Court Barnes?
Mr. Barnes?
Court Barnes?
Mr. Barnes?
Take the one. Your Honor, this is the Corey Barnes on case number 2002 CF 2198. And this is a status conference, Your Honor. Let the court know what's currently happening. Is that Mr. Barnes filed a motion on his own, basically asking for more discovery. I received this a couple days ago. I haven't had a chance to sit down with Mr. Barnes and find out who these people are specifically and why they might be important to his case. That's where we stand, Your Honor.
So what are you asking?
Well, obviously, I'd like to have a continuance, and during the continuance, I'd like Mr. Barnes to be kept in Okaloosa County.
State?
Your Honor, we do not have an objection. For some reason, we did not receive a copy of the motion. Mr. Weinstock let me read it this morning. It appears that the defendant is requesting to set depositions of several attorneys prior. That doesn't appear to be before the court at this time, but we don't have an objection to the continuance.
Stephanie Clifton, do you have an argument? Can you organize something? Just for-
All right, so how far out would you like to continue this?
Well, I have to sit down with my client to find out what he feels these people are going to say. Some of these people, I have no idea who they are. Give you an idea, they're asking for a state attorney employee named Stacy Sorey, of which the state prosecutor says she has no idea who that is right now. He wants me to talk to Michael Flowers, Marty Lester, Jay Crutchfield, Eddie Perillo, and that's about it I can find right now. I have no idea who they are and what they're going to say. So give me a 2-month continuance.
All right. And in the meantime, you wish an order from the court asking that Mr. Barnes remain in Okaloosa County so you'll have ready access? Is that what you're requesting?
Absolutely.
All right. So I'm not sure I want to continue it 2 months without having a status to understand if you need the court to intervene or issue any further orders or whatever might be there, because in reviewing this, the situation is such that it's been, you know, outstanding for some time, right? And so I think that what I'd like to do is just say a month and then just get a status. And if in that month y'all can work together and get a scheduling order which takes care of all of the things that you've just discussed. So for instance, you'll have a chance to talk to your client, review those things, and then work with the state and get a scheduling order about, I don't know, depositions, subpoenas, whatever it might be. Then I won't need a status. But my goal here is to keep the case moving towards a disposition, considering the age and the amount of time it's been pending. And so I don't just want to push it off too, if that makes sense.
I understand.
And if you get that done, then I won't make you come back for the status. We'll move it off the 2 months. So what I'm going to do is say 2 dates, the 2-month date and the 1-month status. And if you get the scheduling order and the scheduling order disposes of those things, what I would expect then at the 2-month date, you should be in a position to be prepared to set the matter for disposition. That makes sense? Or, if not, work with the state to be able to figure out when you can schedule it. Now, I realize you're relatively new on the case, so it's not a criticism, and this information that Mr. Barnes has given you is critical to you being a zealous advocate for his interest. So, but my goal is we need to move it towards disposition.
All right, then what date do you suggest for another
Well, Madam
status?
Clerk, let's do, like I said, I want 2 dates. I want a status date in a month. That would be
August 20th, Your Honor.
8/20 at 9 a.m. And once again, that can be canceled if y'all work out a scheduling order. And then a month after that,
September 24th, Your Honor.
9/24, and what I'm going to call that is, you know, just to pull over the civil area, I'm going to call that a case management conference, because we're going to, at that time, set the case for trial and do whatever else we need to do to set it for disposition. Okay?
What time would that be?
That would be at 9 o'clock. That's a miscellaneous date as well, right, Madam Clerk?
Yes, Your Honor.
All right, and we'll set, that'll be at 9 o'clock as well, with the goal that at that point in time that everybody be ready, tell me exactly what else needs to be done, and then set the case for disposition.
And would you please re-emphasize the fact he has to stay in the area?
Yes, well, that's the next thing. I'll expect an order from you directing that he remain here, so that you will have ready access to him to assist you in the preparing of your case and reviewing this additional discovery and information. But you prepare an order saying he needs to remain here. Now, I'm assuming from, and once again, I'll put on the record because I do, from assuming from Mr. Barnes, the look on Mr. Barnes' face, he's happy to do that so that he'll have ready access to you to be prepared for the trial. Is that right, Mr. Barnes? Okay. Okay. So. Now, anything from the state that I might be missing?
Nothing further at this time, Your Honor.
Okay, all right, so what I'll expect then from you, Mr. Weinstock, is the order regarding Mr. Barnes remaining in Okaloosa County Jail, so you have ready access, and then we'll have the status on 820, and that can be canceled if you and the state work through the details here and get a scheduling order for the other things. And then on 9/24, we'll have a conference where a case management where we'll be setting whatever else needs to be set to get the case to disposition. Okay?
Got it.
All right?
Thank you.
Thank you, Mr. Barnes. Good day, sir.
Your Honor, approaching is James Krolwitz on 24 CF 178. I have filed a motion to take a deposition of the complaining witness in this case, who's about 7, 8 years old at this point right now.
All right. And who's arguing on behalf of the state?
Arianna Leone, Your Honor. I have filed a response objection to his motion. State's opposition to defendant's motion to take deposition based on 92.55 subsection 6. If the victim of a sexual offense is under the age of 12, there is a presumption that the taking of the victim's deposition is not appropriate if the state hasn't filed a notice of intent to seek the death penalty and a forensic interview of the sexual offense victim is available to the defendant. The state meets both those requirements as a not filed death penalty, seeking the death penalty, and there is a very detailed forensic interview of the child who at the time of the incident, or the report at least, he was 7-year-old and now he's only 10. The defense has not indicated the reason why the depositions of other witnesses and a review of the forensic interview is not sufficient for him to prepare his defense. So the state is asking the court to deny the motion to depose the child victim.
The objection I have to the state's comments there is that we feel that because of the forensic interview was conducted inadequately, not only, also incorrectly, and we feel that there's also a number of issues that came out during the forensic interview that are contradictory to actual facts. And the only way to get that resolved is to sit down with this youngster and question him again. He's come up with a number of comments which are not true. And one thing I also noticed listening to the forensic interview is that one of the things that they do in forensic interviews out here in Florida is they make sure that the child knows the difference between a truth and a lie. That's the start of the forensic interview out here in Florida. They never did that when they did the forensic interview out there in Oregon. So I don't know, how about the validity of this interview?
All right, now, everything you're telling me is not within your motion right now. So how does the state know that?
Well, Your Honor, basically, my motion just asks the fact that taking the deposition of this complaining witness is going to be fundamental to my defense.
Yes, sir.
I didn't want to go through all the issues that I just mentioned right now. Be honest with you, Judge, this is part of the defense strategy. I don't want to reveal it to the state. If I can catch the child in lies, then his whole testimony is subject to a question.
I agree. Confronting a witness about a potential inconsistent statement is fundamental. However, the rule says that in order to overcome the presumption, you must present the reasons and substantiate those reasons. You failed to do so in your motion. And so how would the state know how to adequately respond to your request if you didn't say how you overcome the presumption?
Your Honor, not wishing to question you, I don't,
I don't take that as long as you don't talk about my dress or my hairdo. I'm okay with that. You know that, Mr. Weinstock.
I see nothing in the requirements to say I have to explain my defense strategy in a motion.
Well,
There's
the
nothing-
rule says there's a presumption is not appropriate. So if there's a presumption, then that means I should deny it unless you overcome the presumption. And to overcome the presumption, you must do something other than I said so.
All right, then I will file an amended motion to take deposition.
And that way the state would be in a position then to confront, pardon the pun, the assertions of your motion and whether or not it meets the evidentiary standard necessary to overcome the presumption. Now, and you know me, I'm an unconventional judge. I'll change my mind if you've got case law that says I'm wrong. You know, I'm not the one that just says, yeah, do it my way because I said so. If you've got case law that says I'm wrong about that, you're not required to disclose that information, then I'll listen to that case law. But I believe the current status of the law is if the presumption exists because of the age of the child and the circumstances presented and the nature of the charge, then to overcome the presumption, you've got to explain why the presumption is overcome based upon the circumstances. But if you've got case law that says I'm wrong, I'll listen to that, Mr. Weinstock. You know it will.
All right, I'll file an amended motion.
So I'll deny the motion without prejudice. And that's only fair also to the state so that they know exactly what they're facing in argument.
What? All right, fine. Your Honor, that's all I have. May I be excused?
Yes, sir. Now, has Mr. Prowett set for another date, Madam Clerk?
Let me look, Your Honor.
So, you know, no case leaves without another date.
I'm sorry, say again?
I said no case leave, no, you don't leave the courtroom without another date on a case.
He
You
does
know.
not have another court date.
All right, so do we want to set it for the next trial cycle for status, just to have a placeholder? And if you get your motion filed, we can set it another time.
No, that'll be fine. It'll be August 20.
No, it'd be 9/14, sir. Any objection to that, State?
No, Your Honor.
Okay, status on 9/14. If you get your motion filed sooner and get it set, then you and the state can talk about moving it off of the 9/14 onto a miscellaneous date, okay?
9/14 it is.
All right, thank you now, good day.
All right, I'll be in to see you.
All right, Mr. Weaver.
Yes, sir. Good morning, Your Honor. Tim Weaver on behalf of, in the case of State v. Crisby Alexander Queechee Jute, case number 26 CF 483. Your Honor, this is a motion to ask the court to set aside the bond to Streeter and return a cash bond to his parents. Your Honor, in this case, my client failed to appear on May 11, 2026 through no fault of his own. His parents posted bond. ICE had a detainer on him. ICE took him into custody, and he's now been deported to Guatemala. On the court date on May 26, we brought that to the attention of the court, and really the focus was on what do we do that day, and the court did issue a failure to appear in a capias. We didn't address the bond issue. I'm asking for the court to return the bond under Florida statute 90326, or .26, which starts out by saying that if someone fails to appear, the court shall declare the bond forfeited. But as you read further in the statute under section 5, it talks about how the court shall discharge the forfeiture within 60 days. If there's a situation where the defendant it was impossible for him to appear. And the next paragraph under section B talks about if he is in the custody of immigration or in an immigration detention facility, was deported. So I believe it's an appropriate motion to ask on behalf of the parents that their cash bond be returned. And by the way, he's been issued some paperwork by the federal government saying he can't even apply to come back here for 10 years. Maybe an additional fact I think is relevant. He didn't come over here intentionally. He was 7 years old when he came over, and he did what we all do, go where we're supposed to go and where our parents take us. So it's not a situation where he came in here knowingly. I don't believe it's 7, that perhaps he shouldn't have been here. So we're moving for an order to return the cash bond to the parents.
State?
Your Honor, I don't disagree with Mr. Weaver. However, the state doesn't take any position into this matter and defers to the court.
Yeah, the court finds that under 903 26(5) that discharge of the forfeiture is appropriate and the fund should be returned to the poster. And if you'll provide an appropriate order.
Yes, sir. Thank you very much. The next case I have, Judge, it was a matter that I just was retained on. State v. Tyler Gray Shaw. I'm looking for a case number here.
Shaw, you say?
Tyler Shaw, yes, sir. Now, apparently there was a notice of hearing. I've talked to Mr.
Yeah, I show it to be 26 CF 224. Is that right, Madam Clerk? Tyler Gray Shaw?
Yes, Your Honor.
Okay.
And I think there was a notice of hearing for today. He hasn't been transported by the jail, and no one seems to have it on the docket. But
And so my last notes here were that there was an order revoking bond, and then there was a change of plea, withdraw the order revoking bond, but that's the last notes I have, so I'm not sure what the status of the case is. State?
So when we were here last with Mr. Shaw, the state was seeking an incarcerative sentence in Santa Rosa, and he had asked to try to resolve that case first, so that's when we changed the bond revocation to allow him.
That's right, so he could go to Santa Rosa.
That's correct.
And now he's back, and that's what his first appearance was then on 7/9?
I
believe so,
just, I don't know
Judge.
about that part.
Yes, sir. He violated his probation over here, and we're just looking for, what I'm going to ask the court is for another date where I can have a little time to talk to Mr. Chanel, and we'll figure out what to do, and the court can make a decision on what's going to happen.
Because I actually see that he was set for a VOP arraignment today, but I'm not sure why he didn't make the docket.
Yes,
So
sir.
you just want to enter a denial and then set it without subpoenas for next available date?
Yes, sir.
Okay. Did you, yes, I see your notice to appear last week, it looks like. You see that, Madam Clerk?
I'm not seeing it, Your Honor.
Let me see. No, I'm sorry. That's actually from the clerk. Did you file a?
I don't believe I have yet, Judge, but I'll be happy to do that when I get back to the office. If we could just get another date, and we hope to resolve it on that date.
All right, so you are representing, we'll take your notice of appearance today, enter a denial, and set it without subpoenas. How much time do you think you need, Mr. Weaver?
I don't really need a whole lot of time, Judge. We're just, so whenever you have a court date.
The next miscellaneous date we have is 9/14.
Is there
Right,
anything?
is that right, ma'am?
9/14 is pre-trial conference, Your Honor.
What date is it? I'm sorry.
The next miscellaneous date is August 13th, Your Honor.
August 13th, sorry.
August 13th.
Right. No subs, right?
And let me just check. Yes, sir, that's fine, thank you.
Okay.
Thank you
All
very
right.
much. 9 o'clock?
Yes, sir.
Okay,
All
thank
right.
you.
Thank you, Mr. Weaver. Anything else for you?
Yes, sir, I believe we want to approach on the case if we could. And that's all I have this morning, Your Honor.
All right, thank you, Mr. Weaver. Mr. Rare?
Thank you.
Morning, Good morning, Mr. Rare.
For the record, David Rare for Mr. Ricky Valadares, 24 CF 2354. And Judge, we're here this morning on a petition to expunge. And speaking to Mr. Snell for the state, my understanding, notice was issued, but the state has a motion to continue.
That's correct, Judge. The victim in the case has expressed an objection to the expungement, and they need to be afforded an opportunity to be here to explain their objection. So I need a short period of time in order to get someone from that organization here, or at least the opportunity to decline it.
And all I can say to that, Judge, is notice was issued. We and Mr. Valadares are here today on the petition. We cloaked in a presumption that we are entitled to it. State had an opportunity, but we defer to the court on the decision on the motion to continue.
The court notes that the petition was filed on 7/8. The court promptly on 7/10 entered the order setting the case for hearing today, and so less than 2 weeks. I think that considering the state's obligation under the Constitution to reach out and contact the victims and represent the victims' interest, that a short delay, considering how quickly the court set the matter for hearing today, is not unreasonable. So, Mr. Snell, what is the first date in August satisfactory for you?
Yeah, I believe it's 8/13.
I'm going to stop announcing them because I keep getting it wrong. Madam Clerk, what's that date?
The first date in August, Your Honor?
Yes.
August 13th.
All right, 8/13. Now, Mr. Snell, if it ends up that the that the victim is not going to present, then reach out to Mr. Rare and provide the court with such a statement, and I'll simply enter the order without further notice of hearing. There's no reason to require that for you only to announce that the victim has decided that they're not going to say anything, or you see where I'm coming from?
I do, yes, sir.
All right, so set it for 8/13, do your due diligence, and we'll see you then.
Okay.
All right. Anything else for you today, Mr. Rare?
No, Your Honor, that's all I have.
All right, thank you very much. Good day, sir. Mr. Garrett.
Good morning, Your Honor.
Well, I'm not sure if you saw the list, Mr. Garrett.
I did not, Your Honor.
Yeah, come on up. You'll enjoy whoever made the list. Mr. Weinstock made the list, so you'll be happy you didn't get on that list. See at the top?
Yeah, that's good. That's good. I like that. Your Honor, I'm here on behalf of Michael Spoliantopoulos, 25 CF 1712. We were set for status and a potential plea to misdemeanors. We're still putting that offer together. In particular, we're looking for a specific amount of restitution. If we could leave him set for August 13th, he would really like to get this case resolved.
Is it 1712 you say?
I believe so, 25 CF 1712.
So just reset for 8/13?
Yes.
With the state?
There's no objection.
You're going to set it for 8:13?
Yes.
That would be good. Your
Yeah.
Honor.
All right, very good.
Okay. All right, thank you, Your Honor. Have a good day.
Y'all too.
I know.
You put me on the spot.
I don't have it in the gallery. So, we'll see if the court wants to call any pro se. The filibusters work. Chris.
What's your name?
That's, Thomas. I think she wants an Act 205, but he kind of resolutions with it.
You still using the old one? I'm still using.
You are, so you score already?
No, you know we have another version of stuff. I know. It's, in the is in other words now.
All right, Anastasia Stahl, please.
Good morning, Your Honor.
Good morning, Mr. Weisberg.
Attorney David Weisselberger on behalf of the movement, Anastasia Davis Gold, case number 2018 CF 274F, and Ms. Stoll is present in the courtroom, Your Honor.
All right. Ms. Herndon, are you here on behalf of the state?
Yes, Your
In
Honor.
this case, the state intended to traverse or demur the petition.
Your Honor, we would, essentially, it's a demurrer based on the pleadings. We do not believe that the defendant is entitled to the relief that she is seeking.
All right, and
This is not a typical motion under the statute. It is actually filed pursuant to Rule 2.420F, the judicial discretion. I've read through the case law cited by Mr. Weisselberg. I don't think that it is appropriate under these circumstances. This is certainly left to the discretion of the court. The motion to seal has already been taken up with the Florida Department of Law Enforcement. This individual is not eligible pursuant to statute. It is the state's position that the court should not grant a sealing in its discretion, even though the case was previously dismissed.
all right, and help me understand the basis of the state's position on that.
Your Honor, I have looked at the case law that the defense has cited, which are essentially civil cases dealing with the right for closed proceedings when the press is involved. The other case is involving a FDLE sealing pursuant to Statute 943. So what the defense is requesting is that pursuant to 2.420, which allows the court to close proceedings when we have certain statutory factors or enlisted factors under the rule met, and then there is a provision where the court can do it in its discretion based on the interest of justice. It's the state's position that because Ms. Stoll is not eligible pursuant to statute and FDLE has previously denied the motion to seal, even though the case was dismissed, our courts operate with a presumption of openness. There is no valid basis that the court would exercise the discretion based on the material in these records or based on the allegations as pled to seal this particular record.
Mr. Weisberg, you wish to be heard further.
Yes, Your Honor. Thank you, Your Honor. Your Honor, with all due respect to the state, I don't believe that that properly characterizes the motion or the case law or the rules, and the reason is very simple. First, what we're asking for is just as important as what we're not asking for. And what we are asking for is for the judicial record to be rendered a confidential record in a criminal case. And this is not pursuant to the typical Florida statute for expunging or sealing criminal history records, which, as defined by statute, involves non-judicial criminal history records, which are in the custody, possession, and control of the executive branch agencies. For example, the state attorney's office, which we're not asking to be modified. or sealed or rendered confidential. The FDLE records, the arrest agency records, those are the non-judicial criminal history records which Florida statute for expunging and sealing criminal history records captures. In this particular case, we're not asking for those records to be rendered confidential or modified because as our motion discloses, Your Honor, Ms. Stoll does not qualify to receive a certificate of eligibility for expunction order or a record sealing order. The FDLE doesn't make the determination that a motion to seal is not eligible, nor can they deny a motion to seal. That is a core judicial function. All the FDLE does is they fulfill a ministerial legislative function to determine whether or not an applicant meets the eligibility criteria under Florida statute 943.0585 or, which is the expungement statute, or 943.059, which is the record sealing statute. Ms. Stoll, as briefly explained by the motion, Ms. Stoll does not qualify for expungement or record sealing relief under the statute, and we'll go into that. That's why Ms. Stoll is here before Your Honor to present testimony. But to go to the core of how we're here, why we're here, and why Your Honor has the full constitutional power and authority to grant this motion, which is really the crux of the motion, whether or not Your Honor has the legal ability to grant the motion. The case law is squarely on Ms. Stoll's side. And that's simple. It's because we're following the Florida Supreme Court rule under the general rules of Florida General Rules of Practice and Administration. And that's the standard procedure for determining confidentiality of court records in a criminal case, not a civil case. And so we're asking the court to apply the rule as written. And the rule is very simple, Your Honor. First, Rule 2.240, subsection C, subsection 9, lists the grounds under which a movement can move a court to use their discretion to render their records confidential. And that's subsection 6, Roman numeral 6, which states avoiding substantial injury to a party from disclosure of privacy protected matters, and subsection Roman numeral 7, which is compliance with established public policy. And then the rule requires two findings: that the confidentiality that is being requested is no broader than necessary, and no less restrictive measure is available. Your Honor, this is a very simple motion, very simple case, which truly presents no threat to either the law or the public. The equities are just squarely in favor of Ms. Stoll. Ms. Stoll is a member of the Florida Bar in good standing, and she's also a broker. And the public access, the public nature of this court record, given the advent of the internet and how data is transferred with private background check companies, it's a recurrent and substantial injury to her reputation. Because the notation of the criminal history record, the judicial record, which is the one that is captured by private background check providers, it doesn't tell you the story. It doesn't tell you that there was a misunderstanding that led to the arrest. It doesn't tell you that the alleged victims, which are her mother and stepfather, totally and completely denounce any form of criminal activity. In fact, the state dropped the charges because they filed affidavits in support of dismissing the allegations. So we're not talking about a criminal. We're talking about an individual that does not hold public office, that is a member in good standing with the Florida Bar for, I believe, 20 years, And this judicial record, which is not the equivalent of what the case cited by the state in their opposition, the Lewis case, which basically speaks to the issue of openness to proceedings in pretrial procedural posture. This is distinguished by the Supreme Court, and it's distinguished under the Barron case, because the Barron case deals with closed records, and therefore the rule that was promulgated to embed the case law under Barron is Rule 2.420, subsection C9, subsections 6 and 7 as cited by the motion. So, very important for your Honor's consideration is that not only are we staying within our constitutional lane under our separation of powers view, meaning we're only asking for the judicial records to be determined confidential records, but it's a very limited and narrow request that we're making. And there's one more point I want to highlight, Your Honor, before I introduce Ms. Stoll and her mother, who's also in the courtroom. The Florida legislature in recent years passed a new policy for criminal history records, not the judicial records alone, but also including the FDLE non-judicial criminal history records, and that's under the purview of the automatic record sealing statute, Your Honor. And from time immemorial, the case law, the Supreme Court, the language that they used for petitions to seal or expunge under appellate review for whether or not it was properly denied or properly granted, or whether it should have included the non-judicial records in addition to the judicial records. The language was, you only get a second chance. But now the Florida legislature expanded that within a very particular narrow set of circumstances to include unlimited automatic record sealing, meaning if a person today were to be arrested, goes to court 30 days later, the state announces a null pros, assuming that person meets the eligibility requirements under the statute, the automatic record sealing remedy would seal the FDLE record and automatically seal the court record without any judicial intervention, meaning no review, just automatic, programmatic. Here, this meets many of those same elements, but we are just talking about the judicial record, not even the FDLE record, Your Honor. So, if Your Honor has any questions, I'd be glad to answer them. Otherwise, if we could allow Ms. Stoll to address the court.
Yes, you may. Raise your right hand, please, Madam Clerk. Swear the witness.
Do you swear or affirm that the testimony you are about to give will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you.
Mr. Wasserberg, you may proceed.
Your Honor, Ms. Stoll would simply like to address the court, and she prepared some statements for purposes of sharing with Your Honor the background of why she's here, why we're asking for this relief. She's not a criminal defense lawyer, she practices in the civil realm, so if she may just speak with you.
Thank you, Your Honor, for the opportunity to address the court directly. I'm not here to relitigate anything. The state quickly dismissed every charge based on pleas by my family to dismiss those charges in 2018. There was no adjudication of guilt. There was no appeal. And what happened that day was a misunderstanding between my mother, my stepfather, and me. A bad moment with a lot of confusion among a family that loves each other. Not the beginning of anything, not a pattern, not who we are. I want the court to hear that directly from me. My mother, Brenda, is here today to tell you the same thing in her own words, and my stepfather, Michael also wanted to be here too. He wasn't able to travel because of a medical condition, so he's put his own words in a sworn affidavit for the court instead. Both of them asked me to bring this motion. Both of them had told me and told this court that they were never afraid of me, that they didn't want this pursued, that they wanted this motion to seal, and that they simply wanted us to move forward as a family. We talk almost every day. We spend holidays together. This isn't a reconciliation after some break in the family. It was never broken, but the record says otherwise. The court might wonder why I didn't seek an expungement. I could not, because Florida law actually only allows a person one expungement or sealing under Chapter 943 in a lifetime, and I had already used mine. In the 90s, before I went to law school, I was in a relationship that ended in violence. My former boyfriend once asked me to come to his house to collect my belongings, and when I did, he arrested me for trespassing. Not long after, he attacked me violently and was incarcerated, and while he was in jail, threatened to kill me. So I was about to enter the legal profession, and I was terrified that that arrest and this incident would follow me, so I sought and received expungement for that record and tried to block the whole thing from my memory. The earlier expungement is the reason Chapter 943 was not available to me here, and this is why I'm asking this court to exercise the separate inherent authority it holds over its own records, based on the equities and my desire to have the record reflect my character. The record that exists has a real cost. It keeps me and my family, it haunts me and my family regularly. As my attorney mentioned, I'm a Florida bar member in good standing, and I've started my own law practice here in town. I'm also a real estate broker, and I've recently moved my brokerage to a more public client-facing role with a bigger franchise. So every time somebody uses one of these apps that's provided to them by the Emerald Coast Association of Realtors, a free app called Forewarn, just using a reverse lookup, all they need is my phone number, and they can pull my criminal record at no cost. This 8-year-old dismissed arrest surfaces regularly. It actually doesn't show what happened. It just shows that the people that I supposedly harmed have sworn under oath that this never should have happened, that this was a family disagreement. However, the record shows 2 felony arrests against elderly people, which is extremely damning to me forever, to anyone who looks. I'm not asking this court or any other agency to change its records. I understand the difference between the Florida Department of Law Enforcement, what they keep and what this court keeps. I'm only asking for the latter, the court records that are entirely within its own constitutional authority to seal when the ends of justice call for it. So this is a closed case without a conviction. It would help our family in a record today that serves no public safety purpose at all. It only follows me and my family around. I'm a hardworking practicing attorney, a wife, mother of an 11-year-old little boy. We don't drink or do drugs. We're simply trying to build a good life here in Walton County, where I grew up and where I came home to after 20 years to be closer to my family, who I adore, and this little community. I've spent 30 years building a professional reputation built on trust, and I'm asking this court to let a family misunderstanding that hurt no one, and that both people involved have disavowed under oath, to stop being the first thing that a stranger learns about me. Thank you, Your Honor.
Judge, it is the state's position that because it's in the discretion of court and Florida law favors open courts, that this isn't appropriate. We had run an updated NCIC and FCIC. We showed 2 adjudications for misdemeanor offenses out of Alexandria, Virginia as well. This is not something that I have seen for any other defendant that has come before the court, and based upon the rule, we do not think it's appropriate in this case.
But do you have any questions for the witness?
No, Your Honor, I don't have anything for her.
All right. Anything else in support of your petition, Mr. Weisberger?
Yes, Your Honor. One of the alleged victims, Ms. Stoll's mother, is also in the courtroom and has also prepared a statement for Your Honor.
All right. You may call her as a witness. No, she can just be at the lectern. All right, go ahead and raise your right hand, please. Madam Clerk, swear the witness.
Do you swear or affirm that the testimony you are about to give will be the truth, the whole truth, and nothing but the truth?
Yes.
Thank you.
Your Honor, thank you for letting me speak. My name is Brenda Sampieri, and I see his mother. I'm the reason that this record is here at all. And I need the court to hear. My husband and I were in the middle of a family disagreement with Tasia. My only intention that day was to keep her from leaving while we worked things out. Nothing more than that. I called law enforcement because I thought it would help calm things down. And I had no idea that call would result in my daughter being arrested, let alone charged with 2 felony arrests. If I had understood what that call would have set in motion, I would never have made it. We were just trying to cooperate with the officers and even told them we did not want her arrested or to go to jail. And looking back, I remember that my husband fell on her, he grabbed her. She never touched him. I have regretted that decision every day. The state dropped every charge. There was nothing here that warranted prosecution, and everyone involved in that room that day, including me, have always known that. Since then, I have paid the legal cost trying to fix that one call, what that one call cost, both at the time and now, because I feel responsible. What makes this worse is almost no one is looking at the record would even know it involved a family dispute between a mother and her daughter, Anastasia's last name is different than mine, so the record simply reads as though it harmed a stranger. It doesn't show the people she supposedly hurt are 2 people who love her the most and have asked for the very beginning that none of this be pursued. This has cost my daughter professionally and has cost her whole family. It embarrasses us, it hurts us, and continues to follow people beyond just to see it. It even hurts my grandson. Many of our friends, parents, or the real estate community use the 411 app to look up court records, and sometimes just for sport. Which is held against our family. It's embarrassing. Those people don't know what happened except the existence of 2 felonies charged against my daughter. I would do anything to undo what that one phone call started. I can't undo it, but I can ask the court to let it stop causing harm. I'm asking you to seal the record so that my daughter can continue with her legal and real estate career she has worked 30 years for without a misunderstanding I cause following her and our family for the rest of our lives. Thank you, Your Honor.
Any questions?
None, Your
Yes, sir.
Honor.
All right. Anything else in support of your petition, Mr. Weissenberg?
Yes, Your Honor. Your Honor, Ms. Stoll has a video recording of the other alleged victim who is, I believe, ill and therefore wasn't able to attend. If that is acceptable for the state and for Your Honor, he's basically made a short video to address Your Honor.
Judge, we would object.
The state objects.
And if Your Honor is going to sustain that objection, then I do have two more things I'd like to address in response to the state.
I would have sustained the objection.
Understood. Your Honor, Article 1, Section 24, under the Florida Constitution, guarantees public access to judicial records. And I believe the state's argument here, opposing our motion, is not that Ms. Stoll is a threat to public safety, because we've heard of no evidence to support that contention. I believe the grounds, the reason why the state is objecting, if I understand the argument correctly, is that it's because of the public access to records and how this record shouldn't be made a confidential record. Now, what's important to understand here is the chronology of Barron, the provisions that were passed under a referendum to the Constitution enacting these provisions, and the codification of the Barron Rule under Rule 2.420. In short, it is the judiciary's implementation for Section 24 for judicial branch records and DHW. DHW, Your Honor, which is a seminal case in the expungement and sealing world, is a Florida Supreme Court case from 1996, which in essence recognizes that only the courts have the constitutional authority to administer the court system, initiate rules of practice and procedure designed to enforce substantive rights, and therefore the discretion to decide whether and how to seal or expunge court records without interference from legislative requirements. So, the Supreme Court codified Barron into Rule 2.420, subsection C, subsection 9, subsection A, subsection 6, and 7, and sealing under the rules of enumerated exception doesn't limit access as provided by law, but rather it applies the law's provisions at the court's discretion. Meaning, if Your Honor believed that there was grounds and that the rules were met, then this is how the rule would be applied to that enumerated provision for limiting public records. And then Section 23, it says that privacy can limit public records access. But Barron held that privacy could form a constitutional basis for closure of court records. And that's something that was then codified, and now sealing under that rule's own enumerated exception doesn't limit access as provided by law. Again, it applies the law's provisions. So in closing, Your Honor, this is a perfectly constitutional argument where the court has, as a core judicial function, the sole constitutional power and authority under the rules promulgated by the Supreme Court to apply the rules on a case-by-case basis and determine that these records can be rendered confidential court records. And Your Honor, not only are the state's records going to remain public, subject to public access, hence the narrowness of our request and limited narrowness of our request, but so too the FDLE records, so too the sheriff's records. I believe there might be a mugshot that is in the custody, possession, and control of the sheriff's office, which is still public record, but we're only asking for the judicial record. And this can always be undone, Your Honor. If you were to grant our motion, and anything were to happen in the future, which God forbid it were, and we don't believe it will, but if anything else were to happen, the court could always undo what would be done today. So it's very limited, very narrow, and truly tilts towards the individual, which in this particular case, Ms. Stoll has a stellar reputation outside of this blemish. Thank you, Your Honor.
Ms. Herndon.
Just briefly, Your Honor, it's the state's position that Barron is not applicable due to the fact that that was a closed proceeding related to a civil case. Your Honor, the court does have the authority, and it's the state's position that this would not be a case to exercise the discretion in order to do it based upon her prior record, having had something previously sealed or expunged, and 2 other adjudications. It's the state's position that the request should be denied.
Your Honor, may I make a quick rebuttal?
Yes, sir, you bear the burden, you have the right to go last.
Thank you. While Barron may have involved civil records, the principle is one of public access to records. Whether they are criminal or civil, that distinction is made specifically under Rule 2.420 subsection F, which states, request to determine confidentiality of court records in criminal cases, as opposed to the other provision which speaks to civil records. And I'm pulling that up, and that would be subsection E. Request to determine confidentiality of trial court records in non-criminal cases. So this is perfectly within the rules, Your Honor. And we're just asking where the ends of justice in this particular case have been met, in our opinion, that Your Honor grant the relief requested.
All right. After hearing the arguments and trying to quickly review, the court's going to take this under advisement and dig carefully into the cited cases as well as some conflicts which the court has just determined from quickly reviewing the cited cases, and be certain the court's on proper ground. But the court's particularly concerned about Barron, and then the rule, then the amendment to the rule, and how the rule was changed with some of the language, and how that language is then interpreted by the First District Court of Appeal versus some of the cited cases which are from the Fourth, and it appears there's some conflict. So the court's going to resolve those things by drilling down into that case law and being certain that the court is on firm ground. And the court's, just so the parties are aware, if you have any additional issues on this, the court is particularly concerned about, while the court understands that this is a proceeding under the 2 series rules, not the 3 series rules, and there's an issue that the court does retain the independent right to seal documents, or I shouldn't say documents anymore, we refer to them as records under the rule. That the court is also aware that there is some deference that the court should give to the determination of the rule process and the statutory process that the FDLE follows. So I've got to resolve those conflicts as I see them from the quick look at the case law that I reviewed, to be certain that I'm on good ground and making a good decision based upon the prevailing law. And so I'll inform you, and if necessary, then I'll set an additional hearing for further arguments. And once again, the reason I'm explaining what I'm doing to each of you is if you believe there are additional authorities which you need to tender to the court based upon the court's concern, you're welcome to do so. You might not know this, Mr. Weissenberger, because you're not here. Ms. Herndon does. It's my trial week next week and the following week, so I'm going to be jammed up, so there's not like a real rush for you to get this in today. But timeliness is important. I'm going to try to do it promptly. Okay? Any questions?
None from the state, Your Honor.
No questions, Your Honor.
All right. All right. Thank you very much.
Thank you both. Thank you, Your Honor.
You're welcome. Now, good day, sir.
Likewise.
All right, Mr. Powell, are you ready? You need a few minutes.
Yeah, I'm ready, Your Honor.
All right.
Morning, Your Honor. Thank you.
Good morning, Mr. Powell.
Morning, sir. Here on our case that we set over for today. I thought we would have it worked out, but we have an offer that we weren't really expected from the state, and this is case number 2026 CF 130, Ms. ZHAO. And we would ask the court, I think with no objection to the state, to put this on the next docket. Our client, we have to get an interpreter to go over the plea offer. Again, it wasn't what we had expected or talked about, so we're going to have to try to explain it to her. So if we can't get it resolved, we would ask to put it on the next pretrial and trial docket.
All right. And all right, state?
Judge, there's no objection.
So just move it on over to the 914 docket, is that what we're saying?
914 is good, Your Honor, unless there's a, yeah, that would probably be better.
All right, 914 it is. Thank you, Mr. Powell. Anything else for you today?
No, sir, Your Honor, thank you. That's the pretrial?
Yes, sir, that's pretrial conference on 914.
Thank you, Your Honor. Have a good weekend.
Y'all too now.
Bye-bye.
And Charles, I'm going to give that back to you. You know how I am with paper. I tend to collect it. All right. PD, you need a minute? You ready to roll?
I'm ready, Judge.
All right.
All my individuals are incarcerated. Do you have any in the audience?
Grab the reins and the whip and drive the buggy, Mr. McKinney.
Does the court have any pro se on the docket today?
I've got a couple, but I'm not certain. When I looked at them, it was not clear to me that maybe they had counsel. So Julio Ramos Perez shows on my docket without counsel, but that's not clear to me. And that was originally with Mr. Gates, but I'm not sure, and he wasn't transported from, looks like Walton County.
Okay.
So I'm not sure. And then I have Demetrius Rudolph. And clerk, do we have counsel with that?
You was preparing a minute, yes, Your Honor, I didn't see counsel, but let me check in case it updated.
All right. And then I have Anthony Taylor. Come on down, Mr. Taylor. You're here today without a lawyer. Do you want a lawyer to help you, or do you want to hear what the state has to say first? Say again?
I guess I need some help.
Okay. You able to afford an attorney on your own?
Not at the moment.
All right. Do you want me to appoint a public defender to represent you?
Yes, sir.
All right. I'm going to give you actually, Bailiff's going to give you the form. Fill it out. Turn it back in. Don't leave until you turn it in and get a new court date, okay?
Okay.
All right. Hold on just a second. Bailiff's going to give you a pen, I think. And then I have Xinyang.
Judge, this is the case that we had gone from plea day on that was being sent to misdemeanor. There is a misdemeanor case and we did file a dismissal. I think we left this on as status.
Okay. Transferred to misdemeanor court, huh?
Yes.
You show that, Madam Clerk?
I'm looking, Your Honor.
Demetrius Rudolph.
to the no prosecution in the Yang case 26 CF 1147.
All right, very good. All right, Demetrius Rudolph, looks like we continued that from 6/11. He was present without counsel. State? No, actually, it looks like Mr. Koch. No, you sent, Ms. Berrickman sent a notice to Mr. Koch on that case, believing that Mr. Koch was representing the defendant. But I don't see that the defendant has been appointed counsel.
Can we approach, Judge?
Granted.
Before we roll into it, there was an individual on this afternoon's docket, Dejan Kimbrough.
Yes.
In 17 CF 3377, I filed a motion to continue in that case. I don't believe the state objects. Simply for the moving pieces in the back, if we don't have to bring him out. He didn't want to be.
All right, State, you agree?
Dejan Kimbrough.
Yes, yes.
And so when are we continuing it to? Is it with subpoenas?
No, Judge. It's a sentencing, and we are seeking additional time for residential placement.
Oh, that's right. That's my notes. We're still waiting on the Chrome admission, right?
And he was denied for that. We are seeking other options, and we just don't have answers back yet. So we'd ask for 820 for sentencing.
820?
Yeah, no objection, Your Honor.
So we won't need him. John Kimbrough? We will not need him.
All right.
I met with him last night.
All right. All right. I could take a short comfort break. That's
fine.
Yeah, y'all get them lined up and chat, okay? 10 minutes.
All rise.
Court recess, maybe.
I can't find it on my docket, and I can't find it when I search Anthony Taylor. Do you have a case number?
What's first name? There's 3 or 4 people that's on the docket
That I don't
I don't
have.
even know
First, I think we have Nigel Fryer.
Nigel Fryer, please. Do we get, from our, to get that application?
Oh, Mr. Taylor? Did you fill out that application?
Have Taylor's application. Okay, all right.
Did you say? This is Nigel Fryer before the court in 21 CF 192, 20 CF 2443. And we are going to continuance of this matter for a next court date without subpoenas. I'd ask for 8/13, Madam Clerk, if that's the next date. The basis for the violation are pending charges out of Georgia. Originally, this was a YO sentence. There's a good many moving pieces, and we need to put hands on the score sheet as well. So I need to work with Mr. Snell towards getting to a position on what the state's offer is, and what we can do for Mr. Fryer. So I'd ask that we come back on 8/13.
All right, 8/13, no subs.
Thank you, Judge.
Thank you.
Does the court want to take Mr. Taylor? And
Yeah, let's have Mr. Taylor, please. All right, Mr. Taylor, it appears that you do qualify. And there's one thing, you didn't have to post a bond in this case, right?
No, sir. No, RR.
It was RR. All right. It looks like you do qualify. Appoint the public defender to represent you. If the clerk will review this, if they say you don't qualify, they'll tell you why. If you think they're wrong, get everything you have that shows you're wrong, give it to your lawyer, and bring it to court with you next time, okay?
Yes, sir.
Well, Judge, Jason McKinney for Mr. Taylor, he provided my contact information at this time. We would enter a denial to the violation of probation. I did talk to the state to see what this may look like in the future. One of the recommendations without subpoenas.
All right, no subs on 8/20.
Thank you, Judge.
All right, thank you, Mr. Taylor. Stay in touch with your lawyer. Be back on the 20th unless he instructs you otherwise, okay?
Yes, sir.
Thank you now.
Yes, sir. Judge, this is Dennis Hunter. Mr. Hunter is here in 26 CF 707 and 26 CF 858. And the state had made an offer for 1129. We're looking to terminate in this case. I've discussed that with Mr. Hunter. One of the alternative recommendations in this one as well was also drug court. So I've reached out to the drug court coordinator, and Mr. Hunter wishes to be evaluated for that program. I'm going to request a continuance today until the next available date to see where we're at. I believe that's 8/13.
And
Is the state willing to do that?
yes, Your Honor, that we are willing to offer or allow him to enter into drug court, Your Honor.
All right, very good. All right, so continued, no subs, 8/13, or you want 8/20?
Judge, I'd like 8/13 to try to keep hands on it and keep it moving. If that becomes an issue, I can reach out to the court.
All right, very good. Thank you, Mr. Hunter. Good day.
Aspen Wafer? Judge, this is Aspen Wafer before the court in 25 CF 484. I believe that the state has an announcement.
That's correct, Judge. We announced the dismissal of these charges. This was a pay and dismiss situation. It had been left on for status, and we would take no action on the FTA. We did speak with the victim yesterday. He actually is the one who brought this situation to our attention. So restitution has been made, and we announce the dismissal and take no action on the FTA.
Case is dismissed.
Thank Thank you, Judge.
Anthony Weaver?
Judge, Mr. Weaver is before the court in 25 CF 823. This is a mental health court case, but it was placed on this docket because the case was originally here. The position is that it should go back to mental health court for sentencing or further action. There don't appear to be any new charges.
All right, so it should be moved back there for disposition.
Correct.
Okay, so ordered.
Sorry.
Darrell Wisdom?
Judge, this is Mr. Wisdom before the court in 17 CF 3570. And Judge, this is an arraignment on a VOP. We're going to enter a denial and ask for a court date to be set without subpoenas on August 20th. Mr. Wisdom has asked me to research and look into potential placements in Walton County that may be helpful for him. That's something that I would need to research before I discuss that with the state. So that's part of what we're looking at.
No objection, Your Honor, to set it on the 20th, you said, right?
Correct.
Yes.
All right, so ordered.
Joe Petit?
This is Joe Petit before the court in 24 CF 2912. Mr. Petit has been assessed, or is going to be assessed for drug court, and so we would ask to set this on the August 20th date.
All right, status on 820.
Thank you.
Thank you.
Jeremy Redd?
This is Jeremy Rea before the court in 25 CF 1961. May I just have a brief moment? Your Honor, in Mr. Rea's case, we would enter a denial to the violation of probation today and seek a continuance. I just spoke with the state, and it sounds like the offer is 11 months and 29 days in the Okaloosa County Jail. And we'd seek a continuance possibly to the 8/13 date, or 8/20, whichever.
No subs?
No subpoenas.
All right. 813 or 820, your choice.
Let's put it to the 8/20 date.
All right. All right, thank you very much.
Thank you.
Sarah Richard?
This is Sarah Reacher before the court in 24 CF 1424. This is a case where we had an evaluation done by...
It was confidential, and then you decided
Yes.
to turn it into a competency, correct?
Yes, Your Honor.
And the state has received the report, is that right?
Yes, sir.
And the state object?
No, sir.
State accepts the report?
This is the one. No objections.
All right.
And, Your Honor, we would request the court find, based on the court's, or based on Dr. McDonald's recommendation.
All right, the court determines the defendant is not able to proceed at this time and makes a finding. Are we adopting the recommendation of, for restoration in the OCJ? Is that what we're saying? Or do you want to approach?
Yes, maybe.
All right, the court makes the finding and orders the defense to provide an order with the optional language that we discussed at the bench. We'll set it for status for compliance on 8/20.
Thank you.
All right, thank you.
Zachary Rogers.
This is Zachary Rogers before the court in 26 CF2, 26 CF5, as well as 26 CF6. If I may have a brief moment.
Yes, ma'am.
Actually, I do need one more moment. Sorry. Thank you, Your Honor. Again, Zachary Rogers' case. I have just spoken with the state and received an offer of 3 years in the Department of Corrections. At this time, we would deny the violation, ask to set this on the next available court date, but without subpoenas.
All right, is that a guideline sentence, or?
No, sir, it's not.
No.
What is the guidelines?
Mr. Rogers does not score prison.
He's under 44.
Okay, all right. And so set it for 8/20, no subs?
Thank you.
Angela Miller.
Is this? Randall or Conrad? Judge, Mr. Cochran, he should be back in a second now.
She has no attorney, I believe, Jason.
Okay. I believe she has no attorney.
That's what it says on my docket, Your Honor.
Angela Miller, correct?
Yes, sir.
All right. So you're here today without an attorney? Do you want an attorney to help you?
No, I think I'll be okay.
Okay. What's the state's offer to resolve Ms. Miller's case?
An adjudication of guilt, 3 months in the Okaloosa County Jail, revoke and terminate, Your Honor.
You feel like you're in a position to accept that without the assistance of an attorney?
I think I should have an attorney.
Okay. Can you afford one on your own?
No, sir.
All right. I'll appoint the public defender to represent you. The bailiff's going to give you a copy of an application that you need to complete and turn in. I'm going to let you take that back to the jail so you can turn it in from there, okay?
What's your?
And I know you haven't had the benefit of the report at this point in time, Mr. McKinney. It's a failure to report times 2, and then an absconding, and then a failure to pay fees and costs, a failure to complete treatment, and a failure to complete community service hours. The department's recommendation is revoke and terminate county jail deemed appropriate by the court.
May I have just a moment,
Yes,
Judge?
yes, sir.
For today, we would be internet denial and ask for the next available court date. And I'm providing Mr. Cochran's information, and then I'll bring him up to speed on what we talked about here as well.
All right, very good. 8:13, right, Madam Clerk?
Yes, Your Honor.
8:13.
And then call Your Honor.
9 o'clock, no subs. Thank you, Madam Clerk, for reminding.
August 13th. That's all we have to say. Okay. Got some other conversation.
For the court, Your Honor, we have Miss Elizabeth Newton, case number 23 CF 1345. Your Honor, we're going to ask to continue this. There is a DOC offer on the table. My client would like me to talk to the state about potential counters.
And what is,
The offer, Your Honor, as of right now is an adjudication of guilt, revoke and terminate 27 months in the Department of Corrections, and that would constitute a guideline sentence, Your Honor.
So she should be returned back to the trial court.
all right, so continue to what date?
What's the next BOP?
8/13, right, Madam Clerk?
Yes, Your Honor.
8/13 is the next available date. No subs?
No subs.
8/13 it is, no subs.
Sheree Nicholson. Your Honor, we have Ms. Nicholson for the court on 25 CF 1261. She's going to enter a plea today at this time, Your Honor. I have it typed up. She hasn't had a chance to sign it yet. Oh, never mind.
Can we approach, Your Honor, real quick?
Sorry.
Credit for all the time served. Credit for all the time served.
Thank you very much.
We gotta announce that today.
You just need one moment to get the correct. So the state just needs 1 second to get the correct statute number.
If you want to write it on there. 893. Point 135. 1 C 1A.
I think we're ready to proceed now, Your Honor.
All right.
All right, Your Honor, Ms. Sherry Nicholson, case number 25 CF 1261. We've reached an agreement with the state. In exchange for a plea of no contest, the state has agreed for count 1 will be amended to trafficking in heroin over 4 grams, and that statute number is 893.135, section 1C1A. And that will be an adjudication of 3 years, Department of Corrections, with a minimum mandatory of 3 years, a $50,000 fine, court cost, and cost of defense. Counts 2, 3, and 4 will be an adjudication, 3 years, Department of Corrections. Count 4 would be an adjudication, credit for time served, and count 5, adjudication, credit for time served, and count 6, adjudication, credit for time served. And this, she will get credit for any time that she's been in the Okaloosa County Jail towards counts 1 through 4. I have the signed plea form if I may approach. The state is doing an amended score sheet that will be provided.
All right, raise your right hand, please. Do you swear or affirm to testify truthfully in this matter under penalties of perjury?
Yes, sir.
All right, you can put your hand down. And the state intends to file an amended information that is consistent with the charges to which the defendant is pleading?
That's correct, Your Honor.
All right.
Your Honor, before we announce sentencing, my client would like to ask for a furlough before she is sentenced. The state has not agreed to it, but we would like to ask the court for such.
Well, please approach.
We're going to proceed with the plea, Your Honor.
All right. All right. So you heard what Mr. Cochran said and you signed the written plea form?
Yes, sir.
How old are you?
38,
How much education do you have?
12th grade.
You able to read and understand the plea form?
Yes, sir.
Now, there's a lot of moving parts to this that just happened just right now.
Yes, sir.
And you've heard the state is amending the charges.
Yes, sir.
The charges listed on the plea form are the ones you're pleading to. Do you understand that?
Yes, sir.
And the state intends to dismiss the,
That case's not listed, Your Honor, they're just gonna announce.
4625 CF 2303, Your Honor.
okay, so, well, please approach. All right, so with this plea, the state's going to be dismissing the 2303 case that you have.
That's correct, Your Honor.
All right. Do you understand the announced charges that you're pleading to on count 1, count 2 through 4, count 5, and count 6 that were announced, that you're pleading no contest to those charges?
Yes, sir.
And that says to me that you believe the state has the evidence necessary to convince a jury of your guilt, and you're not going to contest that.
Yes, sir.
And by doing this, do you understand that you're waiving your right to a trial where the state would have to prove your guilt?
Yes, sir.
You'll be adjudicated guilty
Yes, sir.
and sentenced to the 3-year Department of Corrections sentence, which is a mandatory sentence. And then on counts 2 through 4, you'll be adjudicated guilty and sentenced to 3 years Department of Corrections. Then on 5 and 6, it's an adjudication with credit for time served. You've got the fees and costs, and Madam Clerk, those are how much?
$615, Your Honor.
And then $150 state-provided legal assistance. And then you have the $50,000 fine, and there's also the clerk's surcharge on top of that, and that you'll have imposed.
With credit for time served?
Credit for time served, yes,
Yes, sir.
ma'am, on
Okay.
everything.
Thank you.
And now, with that, has Mr. Cochran answered all your questions about the plea and how
Yes,
it
sir.
affects you?
Yes, sir.
You're satisfied with how he's represented you?
Yes, sir.
Court will find the plea to be freely and voluntarily entered into and will accept the plea.
Thank you very much.
All right, thank you now.
Your Honor, is that fines to collections?
Yes, do you want all those fines directly to collections, Mr. Cochran?
Sherry, do you want all those fines straight to collections?
Okay, all right, thank you.
Your Honor, I'm running to this printer now to pick up the score sheet for this case, Your Honor.
All right, very good, thank you.
And then, is that the bond motion withdrawn?
And the bond motion is withdrawn, correct?
Yes, it is. Your Honor, we have Ms. Cheryl Oglesby, 25 CF 0587, if I have one moment.
Yes.
Your Honor, we have Ms. Cheryl Oglesby, 25 CF 0587. Your Honor, I'm going to ask to continue this. We need to do my client has asked me to do a bond motion, which I will get filed. The state is also offering Phoenix House, which takes, we have to get an application and such filed. One moment. So as of right now, Your Honor, I'd ask to continue this to 8/13, with the understanding that a bond hearing will be filed.
All right. 13.
Savannah Rachel Marlis.
This is Savannah Rangel Morales before the court in 24 CF 2554, as well as 25 CF 1370. Your Honor, in this case, I believe the intention was for Ms. Rangel Morales to be sentenced in mental health court. She had been in mental health court, and I believe that sentencing is to take place at the next mental health court docket with Judge Reed. So we would ask that this case be placed back on that docket.
And when is that next docket?
I don't have that date. I was hoping.
You need the next mental health court date, Your Honor?
Yes, ma'am.
August 5th at 2:30, Your Honor.
All right, August 5th at 2:30, move it to that docket, Madam Clerk.
Yes, Your Honor. And then one other thing I noticed when looking up her cases is I saw a 25mm 1780 case that shows open. However, I believe that case should be closed.
What was that case number, Ms. Yeski?
25mm 1780.
All right, well, I'm not familiar what county court symbolism means, but the minute sheet says NOP.
Yeah, it's my understanding that that means null pros from my memory, and I was actually representing her at that time. That.
State agree?
Yeah.
I'm sorry, Your Honor. I was writing.
Don't be sorry, just do better.
I was writing, and what was the last thing that you asked?
What does NOP mean on a county court minute sheet?
NOP, notice of something. Somebody was notified of something.
Yeah, I'm reaching out to the clerk who was present at that court hearing. I believe it's supposed to be null pros, but I don't want to give you the wrong information.
Because the last action in the case was on 6/10 of 25. The case remains open, but it sure does feel and smell like it's closed.
Probably. What was the charge?
Battery, touch, or strike first.
And from my memory, I believe the alleged victim showed up.
That's
via
what the minute
testimony.
sheet says.
Your Honor, looking in Odyssey, it looks like it was put in null pros 6/10 of 2025.
Okay. All right.
So it should have been null pros, yes, sir.
Okay, so close the case.
Thank you.
And thank you for bringing it to our attention, Ms. Yeski.
Yes.
Next we have Javarius Lee.
Good morning, Judge.
Good morning, Mr. Nopes.
Javarius Lee, 25 CF 1738. Judge, we are trying our best to resolve this. We just haven't quite gotten it there yet. So can we just put it on for the next pretrial?
State?
No objection from the state, Your Honor. We are close. I think we got to work out some scheduling stuff, and then hopefully be able to play it either on that date or before.
So 9/14 for COP, and if you work it out sooner, you can just put it on one of the miscellaneous dates? Is that what we want to do?
Yes, Your Honor.
Yes, sir,
Okay.
that'd be great.
All right. So that way, if you get it, you can advance it, no reason to just keep coming back, but we'll put it on 9/14 for the next trial cycle. If you reach an agreement, bring it in anytime.
Yes, sir.
All right, very
Will do.
good. Thank you, Mr. Lee. Good day.
Judge, no, I've got out of custody now. So Judge, I then have Ryan Lewis, 24 CF 2709. If I may approach.
Granted. Is he on the docket?
So Judge, we're entering a plea today to count 1, a lesser included trespass, which is a misdemeanor. The state is dismissing counts 2 and count 3. We're entering a plea as charged to count 4 and count 5. They're both misdemeanors. And what we're agreeing to do is to comply with the PTI that's also in the papers that I handed to court. And it's the understanding that in the event that he does not comply with the PTI and he doesn't get everything completed timely, then basically this would just be put back on the docket. The court would decide the sentence on those misdemeanor charges. If he does get everything done on the PTI, then he can terminate early at 6 months.
Okay. All right, so essentially, we're reimposing the PTI with the additional condition of the plea and the possibility of sentencing if a failure. That's what we're doing, essentially.
Pretty much, Judge. I don't know if you say reimpose it. I don't know if it's ever been.
We've never imposed any conditions of PTI, Your Honor.
So it's a PTI with the plea?
Correct, Your Honor.
Okay.
And I just want to make sure that it's on the record that the victim actually specifically requested this outcome, Your Honor, that she is in full agreement with the terms of the PTI.
And Mr. Nopes, if you'll pass the PTI to probation.
Is this going to be misdemeanors and felony?
Yes.
Because they're all misdemeanors.
Mhm.
Yeah, it needs to come to mind.
All right, raise your right hand for me, please. Do you swear or affirm to testify truthfully in this matter under penalties of perjury?
Yes, sir.
Okay, and you put your hand down. You heard what Mr. Nopes said, and you signed the written plea form.
Yes, sir.
How old are you?
44.
How much school do you have?
4 years of college.
All right. You able to read and understand the plea form?
Yes, sir.
Now, you've pled no contest to the announced charges, and the sentence essentially is into the PTI program. And if you fail to comply with the PTI program, you'll be returned here for sentencing.
Yes, sir.
And there's no agreement regarding your sentence, which means that you're facing 1, 2 years and 60 days potential jail sentence on these charges if you fail to comply with the PTI.
Yes, sir.
That's the maximum possible sentence plus the fees and costs. If you comply with the PTI, then the case will be dismissed, and you can do that within 6 months if all the conditions of the PTI are completed.
Yes, sir.
That's what your understanding was?
Yes, sir.
Okay. Court will find the plea to be freely and voluntarily entered into and accept the plea. All right.
Judge, may I approach?
Granted. All right. There you go. And check in with probation before you leave, okay?
Judge, then the last case I've got is Kelvin Watts. Judge, Mr. Watts and I have discussed the facts of the case. There's one issue that I need to get to the bottom about, and it involves a 25 MM 2689 case. And I need to continue it, I guess, to the September 14th for pretrial. I expect we're going to get the case resolved. Mr. Tate's been more than reasonable with their offer. I just need to check on one thing.
All right, so continue to the next without subs, right?
Right.
And do you want, it's 8:13, right, Madam Clerk? Is that good enough, Mr. Knopes?
8:13?
8:13, yeah. Or you want 8:20?
I was hoping we could just go to 9:14. I got to be here anyway.
So, Your Honor, this is not a VOP case.
Oh, it's the new charge. That's right. We moved it here for possible change of plea. 9:14, yes, Mr. Knopes. Thank you. You know, it's still a possibility to change a plea, right?
Yes, sir. Absolutely.
Okay. All right. Thank you very much, Mr. Watts. Stay in touch with Mr. Knopes. He'll be back on the 14th. If he works it out, then we may come back sooner if he has an agreement. Okay?
Yes, sir.
All right. Thank you now. Good day.
Thank you, Judge.
Anything else, Mr. Knopes?
I don't believe so, unless y'all got something.
Not that I'm aware of.
Always,
Okay.
you never know for sure. But
That's correct. You're not for sure.
Yes, we have Jamie McMahon.
McMahon.
Your Honor, this is going to be a plea. I've got to get, there's a second case I need to get a plea form on. So I would ask that he be held and be brought back out once I have that paperwork together.
What is it? What's the other case number?
It's a misdemeanor.
Okay.
I don't have the case number in front of me, Your Honor.
Okay.
I have
All
to
right.
pull that up.
All right, hold him for a plea.
And I'll give that number to the clerk.
All right, very good.
All right.
Kevin Knoll.
Is this Kevin?
Yes, Your Honor, this is Mr. Kevin Knoll, case number 26 CF 0761.
All right, because I also have a Scott Knowles, and be sure we don't have confusion like we did last time.
Yes, Your Honor. Your Honor, we have Mr. Kevin Knoll. We're here for a bond hearing. There was a an offer made, but there's a term in there that my client would not accept. So we would like to go forward with the bond hearing today. Mr. Knoll's present bail is $160,000, which is too excessive for him to afford. He is currently unemployed, but he has a job offer once he gets out at Loftus Marine. He has a residence. His wife is present here today. And so we would ask the court reduce the bond and also remove any no contact order that may be in place. And I'll have some testimony as to the violation injunction charge, Your Honor.
All right. Go forward with your testimony.
At this time,
May we approach?
Granted. Yes.
Your Honor, I'd like to take some testimony from my client.
Raise your right hand. Do you swear or affirm to testify truthfully in this matter under penalties of perjury?
Yes, Your Honor.
Mr. Null, what is your understanding of the injunction that was in place in this case?
The injunction that was in place, I was staying at hotels and campsites, state parks. As the injunction was in place, I was informed that it was dismissed. It was my understanding that it was dismissed the night that I came home. My wife sent me a text message and invited me back to the house, said that the kids are struggling without me there. She's struggling without me there. Come home, let's work this out. So I came home, and that's what happened.
To your understanding, why was the injunction not lifted?
As I understand it, my wife, Hannah, knows the judge that recused himself off the case the day that he got it for the dismissal. It was later dismissed after I was in jail, but as I understand it, and as the paperwork states...
Your Honor, I'm going to object, hearsay.
Well, the paperwork states...
Well, yes, sir. You can't tell us what something else says.
Okay.
You can talk to your lawyer.
Based on my understanding, there was a request for it to be dismissed the day after it was written to be put in place.
Okay.
If the court were to grant you a bond, would you follow any conditions that are put in place?
Yes.
If those conditions included GPS or any kind of pretrial services, would you comply with those conditions?
Yes.
And you have a job offer, correct?
Yes, for a crew leader at Loftus Marine.
Okay. And if you were released, you would be getting, where would you be staying?
With my family, with my kids, my wife.
Okay. I have no further questions for my client, Your Honor.
Any questions for the defendant?
Yes, Your Honor. May I approach the defendant, please?
Granted.
Mr. Kaufman?
Your Honor, at this time, I would object to this coming in. I've just seen this today. There are a stack of pages of supposed messages that I've never seen before, I haven't had a chance to review. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10. There's almost 20 pages of messages here, Your Honor. It's not fair to drop those on me right now.
Okay, you want to continue it so we can have a hearing later?
If I may be heard, Your Honor, those were shared with Mr. Cochran. I was just trying to find the date as to when they were shared.
Oh, okay.
I have discussed those text messages with Mr. Cochran several times, not just text messages, video calls, and jail calls. And I can, one second, Your Honor, they were, one second. Here's. They were shared on, one second, June 19, 2026, over a month ago.
The only thing I have copies of audio, I have audio jail calls. I don't have any written documents. The amended discovery from June 22nd, that's a certificate of service of June 19th. I received it on the 22nd through our system, is jail calls, not text messages.
All right. Well, but we're going to proceed at this point.
May I question the defendant, Your Honor,
Granted.
based on this exhibit?
Is the court allowing the exhibit, is that's the court's ruling?
Well, I haven't admitted it yet. Nobody's moved to admit it.
Well, I would object to her asking any questions concerning the exhibit. Again, based on the fact I haven't seen it other than just now.
Overruled.
Thank you, Your Honor. Mr. Noel?
Yes.
Is this your number, 82771?
Yes,
And this is your name?
correct.
And you wrote this message? It says email to visitor, the visitor being Ms. Clem. Did you write this message to Ms. Clem?
I invoke my Fifth Amendment right as my wife. I don't have to.
Yes, you do. You have to answer the question.
I invoke my Fifth Amendment right.
Your Honor, the state moves the state's exhibit 1 into evidence. I have a certification of business record as well.
Response.
Your Honor, I renew my objection. I have not seen this document.
Overruled. It's admitted.
Yeah.
Granted.
Also, Your Honor, I would note for the record that the person has been identified by the state as being his wife. If you look on the record, it says friend. There's no name saying who that person actually
It says
is.
Scott Andrew.
Yes, Your Honor, because they were using someone else's account. And after they became aware of the state listening to their conversations, they decided to use another inmate's records and proceed to their communication through that.
Go ahead.
I don't have any further questions for Mr. No.
All right. Anything further?
Yes, Your Honor, I would just state for the record, my client has been given a bond. This isn't a no bond situation. He's allowed to have contact with his wife. The no contact was with the children. Your Honor, my client is currently, his bond is currently $100,000 on the child neglect charge, $50,000 for the violation of injunction, and $10,000 for resisting without violence. Considering the fact that my client was under the impression that a motion had been filed to dissolve the injunction, but because of a mix-up in the clerk's office, the order was never signed. I believe that $50,000 is truly excessive. As for the child neglect charge, Your Honor, if you read the probable cause affidavit, no one entered the home to check on these children. DCF has since...
Took them 2 months.
DCF has since sent a closure letter to the family stating that there are no mandatory services. And I think those are relevant for the court to know in deciding and setting the bond, Your Honor. I don't have any further arguments. I would just ask for a reasonable bond to be set on these counts.
Your Honor, state objects. The state believes that $160,000 is more than reasonable. Additionally, I want to make a correction. The first appearance paperwork shows that he has to have no contact with the victim, not to be within 500 feet. Victim includes Ms. Clem and her 2 children. I want the court to know, Your Honor, that this is not an isolated type of crime. This defendant has repeatedly violated conditions of the pretrial release. In our case, by making phone calls from the jail, numerous phone calls and text messages.
Let us. I asked for contact.
Ma'am. Yeah, what the court should consider when addressing a bond modification is, for example, the nature and the circumstances of the case. The pattern of this defendant defying all the orders of court and law enforcement are egregious. Starting from September 19, 2025, he was out on bond on a felony battery out of Santa Rosa County. While he was out on bond on that case, he committed a battery by strangulation and other felonies against his current wife, Ms. Clem. That happened, the arrest was on December 2nd, 2025. Eventually, Ms. Clem, like she's doing now in this case, reached out to the state, advised that she didn't intend on continuing with the prosecution, and the state dismissed those charges. He's still out on bond on the Santa Rosa case when he committed this crime. In May of this year, 2026, he pled to the charges, the felony battery in the Santa Rosa case. And there is evidence in the text messages, Your Honor, that I have provided, that he intends on not listening to any order of the court. There was some discussion about a potential plea with a no contact provision, and he clearly stated that he wasn't going to respect that. Additionally, the text messages, and I'm going to read off of some of them, both Mr. Knoll and his wife created a false sworn statement, and they discussed it in the text messages. Mr. Knoll stated on 5/29/26 at 12:48 p.m. the kids were at the babysitter's so that we could have the night to fix our marriage and undo the paperwork for the divorce. You only told them kids were there because it was late and you were tired. Under duress, lied by the cops, and you knew I had PTSD and didn't want the cops to rush me and they get hurt or I get hurt. She replies, exactly, baby. And you haven't said otherwise since because you thought you would get in trouble if you did. Those facts notarized would destroy their case. I'll write out my updated statement, baby. Okay, memorize it as truth. This is the defendant instructing his wife on how to prepare the statement and what she should state as being the truth, which is obviously not what she told under oath to law enforcement at the time of the arrest in April. And she says, he tells her, memorize it as truth. I'll set the record straight. Then the defendant states, my attorney won't do his job. The whole point in recanting a statement is what then? He should have filed that paper. Now basically is for the context. The defendant is indicating that apparently they told his attorney referring to the false statement. They won't have a case when they realize the kids weren't at the house that night. I told you they would use lies and deceit to get what they want. I need you, this is the defendant telling his wife, I need you to get to my attorney's ass and light a fire. That paper should be the end of all this. I just spoke to your attorney and Ms. Clem replies, he refuses to file statement because we are both on camera saying they were in the house. State would like to move Exhibit 2 into evidence is the Fort Walton Beach Police Department domestic violence questionnaire that was signed under oath by Ms. Clem at the time of the incident in this case, along with the domestic violence lethality assessment.
Objection. It's admitted.
If I may argue it now. So, Your Honor, as part of the investigation in those kind of cases, obviously, as the court is aware, when it comes to domestic violence, there is a questionnaire that the law enforcement asks the victim. In this case, the answers that Ms. Clem gave, has the suspect ever been arrested for domestic violence? Yes. Has the suspect ever been arrested for any non-domestic violence charges? Yes. Has the complainant ever requested injunction for protection against domestic violence or repeat violence? Yes. Has the complainant ever filed a complaint or suspect involved with domestic violence? Yes. This was signed by Ms. Clem. Additionally, the questions, did they ever threaten to kill you or your children? Answer is yes. Do you believe they will try to kill you? Yes. Have they ever choked you or attempted to choke you? Yes. May I approach, Your Honor?
Granted.
What's also important, Your Honor, to notice in this case is the escalating pattern of violence that is proven by his prior record, both from out of state and in state. The defendant scores 53 points only from the prior record. The prior record includes petty theft, various resisting the officer without violence, 3 convictions for aggravated assault on law enforcement officer, 2 batteries, misdemeanor, carry a concealed weapon, 3 different prior violation of injunction for protection against domestic violence, 1 false imprisonment, 1 grand theft, and 1 aggravated battery with great bodily harm or with a deadly weapon. The state has decided to charge, in this case, the defendant with only 1 count of child neglect, although there were 2 children in the house. When he barricaded himself and threatened to either kill himself, he wouldn't get out of the house. The standoff lasted about 30 minutes. And his wife went outside to speak with law enforcement, who had responded there for the violation of injunction. They were calling him out, he refused to get out, and he threatened to either kill himself or that they were going to have to kill him before he would be taken back to jail. The state is, additionally, it is not quite accurate that the DCF report has been closed. The DCF report that was closed was not in reference to this particular case. It was in reference to some other investigation that involved only Mrs. Clem and her children. I have information that the DCF investigation, as it pertains to those charges, is still open. And I personally haven't had the results yet. The state believes, another thing, the address mentioned by the attorney in his motion is the same address where the wife and the children reside, where there is a no contact with. So obviously, he couldn't go back there. He doesn't have any other residence. I know that his family lives out of state, maybe Virginia. So with all those circumstances, Your Honor, I think $160,000 cash or professional bond is more than reasonable.
I have one more here.
Yes.
Your Honor, I recently had a psych eval done on Mr. Dahl by Dr. Zeman, and I recently got the report, and I provided that report to the state. I do not have a copy for this, for the court right now. I just printed one off that I can run and get. But I would like to put a portion of it on the record. According to Dr. Zeman, he believes that at the time of the alleged offense, Mr. Knoll's capacity to appreciate the criminal nature of his conduct and perform that conduct.
Objection, Your Honor.
What basis?
First of all, he provided that to me an hour ago at 10:45 a.m. Second of all, I briefly had a chance to review. It's only based on whatever the defendant told Dr. Zeman. So therefore, it's hearsay.
That goes to the weight, not to whether I'll listen to the argument.
And it's hearsay, Your Honor.
Yes, I understand.
Thank you.
I'll allow the defense to argue.
Thank you, Your Honor. As I was stating, that his conduct to perform that conduct to the requirements of law was substantially impaired. This is based on the fact that my client was not currently medicated correctly because he had been homeless and out of the home. As far as the state stating that my client said he would not abide by the no contact order, I have not provided my client with a plea offer that includes a no contact order until I spoke to him today. And I haven't even conveyed full terms to him. I conveyed to him that there is a probation offer, but it would include a no contact with the children, which is a no-go. But that, prior to today, I have not offered him or conveyed to him an offer that includes a no contact with the children. So that was a misstatement. I think that the facts of the case are important when you look at it through the fact that my client has a mental health history. He has diagnosis for PTSD, ADHD, and schizoaffective disorder. That one is listed by history, which means that it wasn't evaluated for it. But being off his medications was a huge contribution to this incident. If he's allowed to be on bond, he can get back on his medications properly. And that can be a condition of his bond to maintain his medication. The court could ask that he turn in his refill receipts to pretrial services to prove that he's on his medication. There are things that can be done. But $160,000 is unattainable for this client. And he is entitled to a bond. And I think the court should consider that fact in making its determination. As far as the questionnaire, his history speaks for itself, Your Honor. Also, some of those, has he ever done this or attempted to do this? We don't know if that answer is he did it or he attempted to do it. And the language for the children, it's threatened you or the children. Again, we don't know if that threat was ever directed towards the children. I would say that it wasn't, there was never been a threat directed towards the children. It wasn't, I did not realize that the closure letter for DCF that I spoke about was for a different case. I apologize to the court.
Well, that's okay. Sometimes figuring that out is like tracing a Gordian knot, so
Yes,
don't
sir.
worry about it.
Yes, Your Honor. And as far as the no contact, that was one of the first things we asked for, Your Honor, is that the no contact would be lifted along with reducing the bond. Even if the court doesn't reduce the bond, we would still ask for the no contact order to be lifted. Ms. Klim is here. She stated that she wants contact. She's advised the state that she wants contact. The children want contact. They've been asking for him every day. So we'd ask that the no contact be lifted also.
Anything further?
Well, Your Honor, about the no contact, it's obvious from the text messages that have been entered as State Exhibit 1, they are interfering with the judicial proceeding in a material way. So that's the very least a reason for keeping the no contact.
On April 14th, 2026, I, Officer D. Armstead, was dispatched to the address of 329 Miracle Strip Parkway after being alerted of a motorcycle entering the premises after hours. Upon arrival, through investigative means, I was able to locate the whereabouts of the registered owner of the vehicle located at 319 Coral Drive, Southwest, Fort Walton Beach, Florida. The following occurred in summary when attempting to make contact. I made contact with a female identified as Hannah Klim, who was visibly distraught. Hannah informed me that Kevin James Nall, her husband, against whom she has an active injunction, was inside her home and had threatened to kill her. Hannah also informed on-scene officers that her children are inside the house with the defendant. A perimeter was established and contact was made with the defendant through telephone. The defendant refused to exit the residence, at one point exiting and re-entering after observing the officers outside. This caused the well-founded fear that the children were unable to be safely removed. After approximately 30 minutes of negotiation, the defendant exited the residence and was taken into custody. That's the addendum of probable cause on which the court, why we are here today.
Yes, Your Honor. I would say a review of the body camera shows that when he did come out the first time, and the officer, which she doesn't add in this report, is she told him she would have the officers lower the firearms because that was his concern, and that was within 5 minutes of this incident taking place. He opened the door and he observed the officers pointing guns at him, and he closed the door again.
All right. And so then review of the first appearance paperwork says that he has 3 violent felonies on his record, 11 violent misdemeanors, 9 other misdemeanors, and 13 other felonies. It appears that he has, at the very least, 4 other battery convictions. And if the court were under the change in the law going into effect, that went into effect July 1, and the change of the law October the 1st, we would essentially be doing a substantially the same review we're doing now. So the court finds that it's not appropriate to modify the bond nor to change the no contact provisions considering the circumstances presented and the circumstances disregarding even the allegations by the state and taking into account your concerns about lack of appropriate notice, even disregarding the issues with the possibilities of impeding the judicial process or conspiring, quote, quote, to construct a false narrative. Just considering the circumstances presented by the addendum of probable cause, the defendant's prior history of violence, the court finds it's not appropriate to modify the bond conditions, and the motion is therefore denied.
One moment. Your Honor, my client is currently under sentence in Santa Rosa County. Does the court have an objection to him being transported there to finish out that sentence? I could have him transported back for the September 14th court date if he is still under sentence at that time.
What's his sentence in Santa Rosa?
I think it's up in November 22nd. That's if he stays here. If he returns to Santa Rosa, he could be eligible for game time, which would reduce the amount of time he has left on that sentence.
All right, any objection to me actually looking at the judgment and sentence there?
No objection to that, Your Honor.
Adjudicated guilty of felony battery. 270 days in the county jail, credit for time served, followed by 24 months of probation. And credit for time served. So he's 270 days county jail from, looks like, 14 May, plus whatever CFTS he had from that. And I'm not sure what the original arrest date was. Looks like maybe in October, early October of 25. Do you know what his bond situation was? Looks like I guess he was out. There was a motion to revoke bond on 12/4. Then I guess
My understanding it wasn't revoked, Your Honor.
no, it doesn't look like it was. And then there was a subsequent motion to revoke bond on 4/30, and that was probably as a result of the this charge, I imagine. Just let me.
Yes, Your Honor.
So it looks like he was out from when he made bond on 10/30 until 4/30. State's motion to revoke bond April 30. So he doesn't have a whole lot of credit just from the, looks like from the 4. Actually, I don't even see an order revoking his bond. So he would only have credit from the time he arrived back in Santa Rosa, looks like on 5/14. And for whatever time he had before. Now, once again, we're doing this on the fly.
Yes.
Right? So 270 days from 5/14. So, I mean, it's up to the state. I mean,
I don't have any issues, Your Honor, if he needs to go to Santa Rosa.
all right, so we want to then set it off 2 cycles to give them the chance to finish his sentence in Santa Rosa County before he comes back.
When would that next cycle be, Your Honor?
Madam Clerk?
Maybe November?
November 9th would be the next pretrial.
11/9.
Your Honor, at this time, my client would like to leave this set for September 14, or the September, 1 second. Your Honor, we're okay with setting it for the November court date.
All right, Madam Clerk, that date is?
It was already set for September 14th, Your Honor.
Well, we're talking November now, right?
Yes, Your Honor.
November,
Whatever the next pretrial is.
November 9th, Your Honor.
11/9. So you'll need to give me a separate order transporting him back to Santa Rosa with the hold for us.
Yes, Your Honor.
Otherwise, they're going to keep him here.
Yes, Your Honor. I'll get an order now.
All right.
Do you want to cancel the September date, Your Honor?
Cancel September date, continue it to 11/9.
Thank you, Your Honor.
Okay? Granted. Raise your right hand. Do you swear to interpret these proceedings truthfully, adding nothing up, subtracting nothing?
I do.
Thank you. What is your name, please?
Julio Manuel Ramos.
All right. You're here today without a lawyer. Do you want a lawyer to help you?
Is this Ramos Perez?
I should have Mike Gates.
All right. I'm not sure that Mr. Gates was informed about today, just reviewing the progress docket, because you weren't transported last time. I apologize, I don't show him as counsel for Mr. Ramos, do you, Madam Clerk?
No, Your Honor, I see a motion to withdraw. He represented the defendant during the initial proceedings, but looks like he's not representing him at this moment for the violation.
Mr. Gates has filed a motion saying he is not representing you for the violation of probation. Do you wish to have a lawyer represent you? Do you want a chance to reach out to Mr. Gates and see if he will accept representation of you? All right.
Yes.
All right, so we'll continue this to 8:13. If you can't arrange for Mr. Gates to represent you or someone else, you can file an application for the appointment of the public defender if you so wish. All right, thank you.
Scott and all.
Your Honor, this is going to be a plea if I have one moment for signatures. We're ready to address Mr. Scott Knowles, 24 CF 2763. Your Honor, in exchange to admit the violation, the state has agreed to term and revoke 14.25 months Department of Corrections. That'll, with credit for any time that he has served in the Okaloosa County Jail, plus 5.9 months that were spent in custody in Georgia. Any outstanding monetary obligations would go to a civil lien, and we would ask that any cost of supervisions that were in arrears to be waived, so that he can pay there is a restitution amount of about $1,900. I would ask, to waive the past supervision costs so his money could go towards the restitution rather than supervision costs.
All right.
I have a signed plea form and the score sheet. Yeah. 1 second. I'd asked to set this for 8:13. My client didn't realize that this would require him to be sent to DLC. So he wants to take some time to think about it and take care of some stuff with his family.
I didn't know I was gonna be more further, so.
So 8:13 for a change of plea, is that what we're saying?
That's what I'm projecting, yes, Your Honor.
State, leave the offer open till then?
Yes, Your Honor.
All right, 8:13 it is. It's time. Madam Clerk, who we have left?
First one I have is a Terrence Walton, 24 CF 1931.
Judge, that's my case. He is going to be sentenced federally. They pushed that sentencing back to the 13th of August, so I would ask for the date after August 13th. I believe that if we have 8:20, that should work as a status to make sure that the federal sentence goes through.
There's no objection, Your Honor, to the
All right,
20.
8:20.
That's 9 a.m., no subpoenas.
No subpoenas.
last one I have is Zachary McLean with two case numbers, 24 CF 2776 and 26 CF 1109.
He's present in the courtroom.
Yes, he's present, Your Honor.
Good morning, Your Honor.
Your Honor, we have Mr. Zachary McLean, case number 261109, and 24 CF 2776. Your Honor, this is, we're close to a plea. There's just one issue with restitution. My client wants to get a better answer on that before he enters a plea agreement to pay restitution. So I'm going to talk to, I'll be talking to the state about that. They know that that's our concern. So I asked to leave this set for the 9/14 court date.
No objection from the state, Your Honor. I have spoken with defense on this, and we are working on getting a receipt that verifies the restitution amount, Your Honor.
And we would enter a denial for the violation of probation, Your Honor.
Okay, all right, 9:14 it is. Stay in touch with Mr. Cochran and be back on the 14th unless he instructs you otherwise.
Thank you, Your Honor.
All right, thank you. Go ahead, Madam Clerk.
And then all I have left, Your Honor, is the Jamie McMahon for the plea.
And I'm doing that paperwork right now, Your Honor.
Okay.
I should be ready to come off of 130, which would be Mario Williams, if we wanted to turn to that.
If they're ready.
Mario Williams Jr. is in the 100 docket. It's going to be a probation plea, so as soon as he walks out, I'll let you take a picture. Jason McKinney on behalf of Mario Williams Jr., 26 CF 1191. This is set for arraignment. The state has filed a one-count information. We are going to be entering a plea of no contest, and we have reached an agreement. The agreement calls for an adjudication of guilt, 2 years of probation, with substance abuse evaluation and treatment, no trespass at Publix, no contact with the victim, Jeremy Gartman, Gartman, $515 in court costs, $150 cost of defense. May I approach probation, let them take a picture right quick?
Granted.
This is what you want to do today. May I approach with the plea agreement?
Granted.
Score sheet reflects 21.8 points, no objection.
All right, raise your right hand for me, please. Do you swear or affirm to testify truthfully in this matter under penalties of perjury?
Yes, sir.
Okay, you put your hand down. You heard what Mr. McKinney said and you signed the written plea form?
Yes, sir.
How old are you?
32.
How much school you have?
11th grade.
You able to read and understand the plea form?
Yes, sir.
And did you do that before you signed it?
Yes, sir.
And it's what you read in the plea form, what Mr. McKinney announced?
Yes, sir.
Do you understand you're pleading no contest in the announced charge?
Yes, sir.
That tells me you think the state can prove your guilt and you're not going to contest that. You understand by doing this, you're waiving your right to a trial where the state would have to prove your guilt. In this case, you'll be adjudicated guilty, 24 months of probation, evaluations. You can't go back to Publix, can't have any contact with the named person. You got the fees and costs to pay.
Yes, sir.
Mr. McKinney answered all your questions about the plea and how it affects you.
Yes, sir.
You satisfied what he's done for you? The court will find the plea to be freely and voluntarily entered into. I'll accept the plea. If you step over this way, please. And let's just go ahead and take our lunch. If we just keep going, we'll end up without a break at all. So we'll just go ahead and then Mr. Cochran, you can just bring him on back when we come back for our 1:30, okay? All right, so we'll go ahead and take our recess now to 1:30.
All right.